Well, welcome everyone, and thank you so much for joining us today here. My name is Lior Samfiru. Yes, I'm the employment lawyer, and welcome to this live employment law session. So, for those joining us for the first time, this is where you get to ask questions about employment law. And I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. You see us often on TV, on radio. You see us online, and I'm right here to help you answer and get answers to your employment law questions. Whatever the issue, there are answers and there are solutions. So many times I get people that are surprised when they ask me a question that there's actually a solution to their problem. They don't realize that we have such good employment laws. The laws can't do anything for you unless you know what they are, unless you realize what the rights that you have are in the workplace. Lots of rights. Whether you lost your job, you have rights, you have significant entitlements. Whether you're dealing with an employer that's deciding to make changes to your employment terms, you have rights there. Maybe it's a temporary layoff. Guess what? Not legal. You have rights. Whether it's a situation where you're being bullied, mistreated, harassed in the workplace, you better believe you have rights. I think you get the idea. And on this session right here, every Thursday at this time, every Wednesday at this time, we talk about your employment rights. We tell you what you need to know, and we help you find some solutions. Now, before I get started with live questions, let me give you some other contact information. If you want to connect with me and my team across Ontario, BC, and Alberta, very, very easy to do. Just go to employmentlawyer.ca right there on the screen, right there, employmentlawyer.ca. And when you go there, you'll see the phone number, the email address. You can read a lot more about employment law. There's so many resources there that are available to you, and I'll tell you more about resources later. But right now, I'm live. I want you to ask your question. I've seen questions coming in already. Thank you for that. I'm going to start answering them in just a moment. And if you're joining us for the first time, this is it. You have a box on the screen. You type in your question. You hit enter. I'll see it. I'll read it. I'll answer it, and you're done. So take advantage of that. Again, I'm Lior Samfiru, the employment lawyer, live with you, for you. Employment law is what we're talking about. So let's get started. All right, question on YouTube from Sir. If you are given 2 weeks notice of termination and do not show up to work for those 2 weeks, is this grounds for termination for cause? Well, yeah. If your employer gives you advance notice of termination, so if your employer tells you, we're letting you go in 2 weeks, 3 weeks, 6 months, they give you advance notice. If you don't come into work, you just haven't come into work. That means you've resigned, or you could be let go for cause, just like not coming into work any other time. Now, if you miss work 1 day, that's not going to be enough. But if you decide you're not coming in and your employer's following up with you and you say, too bad, I'm not coming in, then you've resigned. The problem with that, and this is the key is this, you may be owed an extra 10 months of severance at the end of that 2 weeks. But if you quit and you don't come in for those 2 weeks, you've given that up. So not a good idea to do that. If you get advance notice of termination, remember that if you're not going to accept it, if you're going to not come into work, you potentially can be giving up a lot of severance that's owed to you. If you don't care, if you don't want to work anymore, or maybe you found another job, that's fine. You can do that. But understand that you could be walking away from entitlements that you have. So hopefully that answers the question, sir. If you have any follow-up questions, please ask them. See how easy that is? Answers right here. Employmentlawyer.ca is where you can find more about me and connect with me. But right now I'm here live, Lior Samfiru, answering your questions. Questions coming in. Ask your question. You have time. Let's get to it. From Stevie on YouTube, Stevie asks, what sort of rights do you have if you are a flat rate employee? Well, you have a right to get paid what you've agreed on. You still don't have to make at least minimum wage. So what I mean by that is for the hours that you work, you have to at least get paid minimum wage based on the province that you work in, the amount of hours. So your employer can't say, sorry, it's a flat rate, so it doesn't matter how many hours you work. No, it's flat rate is fine, but it has to be at least the equivalent of minimum wage given the hours that you work. Now, talk about rights. If you lose your job, you still have to get paid severance, and severance has to be paid based on your average earnings. So if you always earn $700 a week, as an example, then that's going to be the amount calculated to pay that severance. Okay, so Stevie has a follow-up question. He says, we get paid for completing specific jobs, but if there's no work, we don't get paid for the day. So if that's the deal that's been in place since the beginning when you started this job, then that's the deal that you reach. If you used to get paid always and now your employer change it and say from now on we're not going to pay you on certain days, they can't do that. But if the deal has always been, if we have work, you come in, you do the work, otherwise you don't do work and you don't get paid, unfortunately that's okay. It may be frustrating, I get it, but that's the deal that you reach with the employer. So your employer can't change the deal, but if they're following the deal that's been in place since the beginning, that they can do. So thank you for that question, Stevie. Hopefully that makes sense. Any follow-up, please ask. So again, I'm Lior Samfiru, the employment lawyer with employmentlawyer.ca, and I'm here live answering your questions about employment law, workplace rights, your job, your compensation, your boss. You got it. Penelope Quick has our next question. I'm attending a work conference next month in the US. We will be working a full day on Saturday and a half day on Sunday. Normally, we are closed on the weekends. Are we owed back time? So I'm not sure what you mean by back time. Are you talking about overtime, perhaps? So you would be owed overtime if you work more than the overtime threshold. I don't know where you are, but if, for example, if you work in Ontario, then it'll be 44 hours a week, even if you're outside of Ontario. So anything over 44, you'd get overtime unless you are a manager. So if you're a manager, managers are exempt. That said, if you're an hourly employee, then of course you have to get paid for the time you work on the weekend. So that's the answer there. You're owed overtime if you work more than the overtime threshold. If you're on a salary, but you're still going to work less than the overtime threshold, you're not going to be getting overtime. I think that's what you mean when you say back time. I think you mean overtime. So hopefully that makes sense. All right, let's see. Our next question comes from Anna on YouTube. I was injured at work and my employer did not take care of my injury. Do you have an office to contact in Calgary? Yes, we have an office in Calgary. You can connect with me and my team through employmentlawyer.ca. So let's talk about injury. You say that your employer didn't take care of your injury. So what your employer has to do is give you the time. You can apply to workers' compensation, of course, but your employer has to give you the time off that you need to get better. If you have medical restrictions, they have to accommodate that. Maybe you need modified duties and modified hours. If that's what your doctor says that you need, they have to provide that. But beyond that, they don't really take care of your injury. Your doctor does that, and you can get additional compensation and even referrals through workers' compensation. Your employer simply has to make sure that you're given the time off to get better and that you're accommodated if you need accommodation. If your employer didn't do that, Anna, if your employer is not accommodating you, so they're not following your doctor's advice, or maybe they're not allowing you time off work, they don't believe your doctor you need to be off work, you need to give me a call as soon as possible, okay? In that situation, because that would be illegal. So Anna, to connect with me and my team, you go to employmentlawyer.ca. Again, employmentlawyer.ca. Yes, we do have an office in Calgary, great team in Calgary, so we'll be happy to help you. You can reach us there anytime. Thank you for that. Let's see here. By the way, if you've just joined us now, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, here live answering questions about employment law. Still have time. Last week, it happened again. I always say that it will happen, and it did. Just as I said my goodbyes and I turned off my camera last week, a bunch of people asked questions, and I didn't get to them. Don't let that happen. You have time now. Got still another 20 minutes or so. So why stress over it? You have time. Type in your question. Make sure your question is exactly as you want it, and I'll see it, and I'll be able to answer it. Okay, so let's get those questions answered right now, and I'm going to continue doing that just now. Let's see. Let's see here. Where did I leave this off? Next question comes to us from Fred. How difficult is it to prove age discrimination? So it can be difficult in some situations, but in other situations, it's obvious. So I'll give you an example where it's obvious. Let's say a company has 15 people doing a similar job, let's say working on the assembly line. And there's 2 of them are older people, and those 2 were let go. and no one else was let go. And well, all of a sudden it seems pretty obvious, right? There would have to be a really good explanation why those two people, why not someone else that happened to be old. So in some cases, it's obvious what's going on here. You're never going to have 100% proof. You're never going to have an employer putting in writing, we let you go because of your age. It's never going to happen. But in some cases, it's very, very obvious. In some cases, it's not obvious. It's going to be more difficult. That's why the facts matter. But oftentimes, if it looks like age discrimination and it feels like age discrimination, it probably is age discrimination. And an employer that engages in age discrimination, once we call them on it, they then have to not prove, but they have to explain why it wasn't. And if they don't have an explanation, it's going to be age discrimination. Of course, age discrimination is illegal. It's a human rights violation. You cannot be mistreated, fired, disciplined because of your age. Illegal. We don't have mandatory retirement, by the way. You can work as long as you want, and your age should never even be a factor in any decisions that your employer makes. So your employer may say, well, we fired you for 5 reasons. Well, if one of those reasons, even not all 5, but even one of them was your age, it's already illegal. So keep that in mind when it comes to age discrimination. Not acceptable, a human rights violation. If you ever feel that you're dealing with an age discrimination situation, give me a call. Of course, to connect with me, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca, easiest way to do that. Phone number is there, email address is there. But right now I'm live, going to continue answering your questions. Bren has our next question. What happens if your employer decides not to bring you back for the next work season? Seasonal work, doing it for 8 years. So if they don't bring you back, that means they've terminated your employment. That means they have to pay you severance. So you can't force your employer to bring you back. But if you've had a consistent job for 8 years, you expect to be brought back, and every year for 8 years you've been brought back for the next season. If they don't do that, the law considers that to be a regular termination. Now they have to pay you severance. Depending on the job, so you say you've been there for 8 years, depending on your job and your age, you could be owed anywhere from 6 to 12 months of severance. Of course, the more senior a position, the older you are, the more severance you're going to be owed. But it could be as little as 6 months. It could be as much as 12 months. So by all means, if that's what happens to you or your friend or your neighbor, if they've been working for a few years and now the employer says, now we're not going to bring you back anymore, now we're going to do something else, that's a termination. We call this a termination without cause, meaning severance has to be paid, and that could be a substantial amount. So in that situation, you know what to do. You reach out to myself and my team through employmentlawyer.ca. I will make sure that you get everything you're owed. Thank you. Very good question. So thanks for that. Next question comes to us from Fred. My work RRSP is frozen by my employer until severance case is finished. Can they do that? I'm paying for fees I could have put in a GAC with a much higher return. Are they liable for shortcome? Yes, they are liable for the shortcome, but if you have a good lawyer, they should be able to deal with that. Okay, they should be able to get the company to do what they're supposed to with the RRSP. So it shouldn't be an issue. Okay, it shouldn't be an issue at all. So let's make sure that, if you're not getting proper representation, we need to talk about that. Okay, you may need to have that taken care of. So Fred, to connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. Let's chat about that. Bren has a follow-up question. Bren was saying, what happens if your employer doesn't call you back to work after 8 years at the end of the season? It says, does it make a difference if we have to sign new contracts annually? No, it does not make a difference. Everything I said before, that you're owed severance, still applies. So you got to give us a call. Again, employmentlawyer.ca. More questions are coming in. I see them. I'm going to answer them. But you as well. You're watching. That's great. But let's get you some answers to your questions. Either it's a situation that you're dealing with right now. Maybe it's something you've always wondered. You've always wondered, hey, can my employer actually do this? They've been doing this for a while. Is this even legal? Well, ask right now, and I'll tell you. Or maybe it's for a friend, a family member. They're dealing with something. Ask the question. Maybe you can give them some helpful information later on today. So again, to connect with me after the session, That's employmentlawyer.ca. But for the next 15 minutes, I'm still here answering your questions live. So let's make sure you get those answers. Just like Liz has a question. I have already resigned because of constructive dismissal due to not getting accommodation for disability. Is it now too late to take action against former employer? Well, if you resigned 2 years ago or less, then no, it's not at all. But if it's been more than 2 years, unfortunately, you're going to be out of time. So that's the key. 2 years is that limitation period. If your employer doesn't accommodate you, so your doctor says, here's the accommodation that you need. Employer says, yeah, we don't care. We're not going to do that. Well, number one, you're right. That's a constructive dismissal. But number two, that's also a human rights violation. It's illegal. They have to. It's not an option. It's not a nice to have. They have to provide that accommodation. There's no choice here. So you have to contact us. Okay. But there is that limitation period. In fact, that limitation period can even be shorter with on the human rights front. So certainly, Liz, you want to contact us today. If it's been more than 2 years, unfortunately, you're going to be out of time. We can help you, but if it's been less than 2 years, or then we need to speak right away today. And to connect with me, very, very easy. Employmentlawyer.ca. Again, employmentlawyer.ca. Now, I've mentioned severance a bunch of times already. I told Bren before, it could be anywhere from 6 to 12 months of severance. Well, how do you don't have me in your living room all the time. So how do you find out, even when I'm not around, how much severance you're owed? Maybe you want to know right now, how much severance am I owed if I lose my job? Or next week, if they let me go on unexpectedly, what would they owe me? Easy. You can find out right now. We have a severance calculator tool. You can find out by going to pocketemploymentlawyer.ca. The address is on the screen right now, pocketemploymentlawyer.ca. When you go to pocketemploymentlawyer.ca, you'll see our severance calculator tool that I mentioned, and you can answer a few questions, and it's going to provide you with an assessment of how much severance you are owed. It's completely free. It's completely anonymous. You don't have to put in your name. You don't have to put in your email address. You don't have to put in the company's name. It's just there for you. If you want to, and only if you want to, you can even contact me directly from the severance calculator, but only if you want to. Otherwise, you take the information and you're done. Always the very first place you should go to if you lost your job, if you're interested in finding out how much you're owed. And I can almost guarantee you that the severance that you're owed is more than you think. It's more than you believe than it is. Don't believe me? Check out right now, pocketemploymentlawyer.ca. Go to the severance calculator, see for yourself. All right, but right now I am still live answering questions. Nathan, you're up next. You as well. If you have questions, let's get them answered. So Nathan says, I've been an independent contractor for 3 years with a large company. They didn't renew my contract this year and reduced my purchase order from 70K to 40K in my last year. They want to offer me a full-time role, which I declined to stay as a contractor. Does that impact my eligibility for severance or possible misclassification? Now, again, I don't know about what kind of hours do you work? I don't know if you work for anyone else or if this is your only job. I don't know if where do you physically work? Do you work from home? Do you work on the road? Do you work from the company's offices? But here's what I can tell you. 90% of people that are called independent contractor are really misclassified. They're really employees. So there's a very good chance that you are an employee that has been misclassified as an independent contractor. If you look like an employee and you act like an employee, then you are an employee. It doesn't matter if they call you a contractor. It doesn't matter how you pay your taxes. None of that matters. And if you're an employee, yes, you are owed severance. And after 3 years, again, I don't know your age and exactly the job that you were doing, but you could be owed easily 6 months of severance, easily. So there's a lot at stake for you. Now, I'll give you something else. Even a contractor, in many cases, is owed severance. There's a category called a dependent contractor. A dependent contractor is someone that's not an employee, but because they get most of their income from one company, that company still owes them severance if they let them go. So you are likely, whether you're an employee or a dependent contractor, still going to be owed severance. So Nathan, you want to call us as soon as possible, and let's make sure you get that severance, okay? To connect with me, Nathan, and my team, in Ontario, in British Columbia, in Alberta. Easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Great question. Thank you for that. Right. Great questions today, guys. Keep them coming. Again, I'm Lior Samfiru, the employment lawyer with employmentlawyer.ca, here for you at your service, answering questions. Just like the next question on YouTube from Hodlin. I've been working for a big company for over 25 years. I would like to leave, but they told me if I leave, I will get nothing for severance pay. Is that true? Unfortunately, yes. Severance is not paid if you decide to leave, to resign, or to retire. Severance is paid if the company lets you go, or if, of course, you can also get severance if the company did something to you that forced you to leave. But if you leave voluntarily, unfortunately, you don't get severance, even after 25 years. Severance is paid if the company decides to let you go, then they have to pay severance. In your situation, if the company lets you go, they'd potentially owe you 24 months pay, okay, which is the maximum that generally people are owed. So hopefully that makes sense, Hodlin. Any follow-up questions, issues, problems, you know what to do. Reach me through employmentlawyer.ca. All right, fantastic questions. I'm going to keep going. Sean has our next question. Are discrimination cases difficult for attorneys, even with emails, to prove it happened? No, they're the easiest cases in the world. If I have emails to prove it, it's easy. I can do those in my sleep. So I love having that evidence. If I have the evidence, I can sit back and make sure that the matter gets resolved very quickly and on very, very good terms. So no, it's not difficult. Where it becomes more difficult is if we have no proof, the company is denying it, then it gets more challenging. Still doable, but if we have emails proving it, easiest case in the world. All right, great question. Next question, Roseanne on YouTube. Can bonus be withheld based on signing off on severance offer? Well, it should not be. No, if you've earned the bonus, it should be paid. The reality is most companies are going to use that or try to use that as leverage against you. Don't let that happen. Once we get involved, we'll get you the bonus, we'll get you the severance that you're owed. So don't fall for that bully tactic. Okay? If you lost your job, or we're talking about your friend, your relative, etc., make sure they call us. Don't ever try to negotiate that severance on your own. You're going to be at a huge disadvantage. Okay? Should they be withholding bonus? Absolutely not. Are they going to try to do it? Likely. That's why we need to get involved. So Roseanne, reach out through employmentlawyer.ca and let's make sure that you get everything that you're owed. Let's see here. More questions. There we go. Linda from Facebook. Linda says, when employers install security cameras in the workplace, where should they be installed? Can they use them to record conversations and manage staff? Does this violate any privacy rights in the workplace? Are they allowed to place hidden cameras? So let's break this down. Your employer can generally track what you're doing in the workplace. So in any area that's controlled by the company, they're allowed to record. They're allowed to use cameras. What they can't do is, of course, in a private, there's certain areas that are expected to be private. If there's a change room or a bathroom, of course, they can't do that. But at your desk and the hallway and the lunchroom, yeah, they can have cameras there. Now, in terms of recording conversations, they can only record conversations if they tell you that they're doing that. So if your employer is saying, just so that you know, we're going to be recording your conversations throughout this place, so don't expect privacy, they can do that. If they don't tell you, but they record your private conversation with someone else, that is not legal. Okay, they cannot record your conversation with someone else if you don't know you're being recorded. So that could actually be a criminal offense. So that's the difference. If they tell you and you know you're being recorded, that's okay. If they're doing it in secret, not okay. Hopefully that makes sense. Any follow-up questions, you know what to do. Reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see if we can get in a couple more questions here. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, all over Ontario, BC, and Alberta. Got a few more minutes. I want to answer a couple more questions. Let's get those done. Jason, next question. I had my lawyer send a demand letter and they returned one stating different reasons to terminate me, but I have proof of the reason I believe they did. What's my next step? Well, okay, I think your next step should be obvious. You talk to your lawyer, right? That's why you have a lawyer. So that has to be your next step. I'm not going to tell you what your next step is. I haven't read the letter. I don't know anything about your situation. Your next step is to talk to a lawyer. But I'm concerned a bit here because you should know that. So if you're not comfortable talking to your lawyer, maybe there's an issue there. If your lawyer is not doing his or her job, you need to speak to someone that will. Okay, so if you think your lawyer is not being helpful, I'm happy to talk to you or have my team talk to you. But your next step is to talk to your lawyer. That's why you have one. So again, to reach me, my team, employmentlawyer.ca. All right, next question comes from Keith. The employer has knowingly stated an incorrect length of employment on my file. If I'm seeking damages for unlawful dismissal with cause, can I sue them additionally for falsifying information on the record of employment? No, not really. Ultimately, you shouldn't care so much about that as long as you have enough hours to get EI, that you're owed. So if you have 5 years and they say that you have 4 years, it doesn't matter because you're going to get your maximum EI even with less than that. So I wouldn't worry about the record of employment. It doesn't matter. Okay. Now, what it does matter is if you have an employment agreement that shows when you started working, we're going to need that if we pursue your severance, because we want to show you were working for this amount of time. The longer you work, of course, the more severance you're owed. So you want to make sure that there's actual proof as to when you started. But I wouldn't worry about the record of employment. Now, where it becomes an issue is, let's say you've worked for a year and they say you only started 4 months ago and they let you go, then you're not going to qualify for your maximum EI. That's an issue, and we can get that fixed. But if you're going to get your maximum EI, it doesn't matter. The record of employment is only relevant for EI purposes. As long as you're getting EI, I wouldn't worry about it. I wouldn't lose any sleep over it because it's not going to matter whether it says 5 or 7 or 27 years. Either way, you're going to get EI. So hopefully that makes sense, Keith. Any follow-up questions? Employmentlawyer.ca. Let's get to our last question today, and that is going to be from Mr. Bilson. How much working notice should I be given for 5 years of employment? What if I'm given 1 week? So the amount of working notice that you're owed and the amount of severance, they're the same. And they're based on your age, your position, and the length of your employment. I don't know what kind of a job you have, and I don't know your age, but you're probably looking at somewhere between 5 months to 10 months, depending on your age and position. It could even be more than that. If you're given a week, it means that the company has to make up the difference by way of severance. So if you're owed 6 months severance, let's say, and the company gives you 1 week's notice, that week counts towards your severance, meaning they have to pay you now 6 months less the week notice that they gave you. So that's what happens. So if you lost the job, you call us right away, employmentlawyer.ca. And okay, I'll give you another reminder here. If you want to find out how much notice or severance you're owed, pocketemploymentlawyer.ca. Use our severance calculator. Over 2 million people, close to 2.5 million now, have used it. Use it as well. It's free. It's anonymous. It works great. And it's there for you if you need to know your rights. Okay, guys, thank you so much. This is the time that I have today. I'm really glad to have had this opportunity. I'll be back next week with you as well. My team will be back even before that. But if you have an issue that requires help, don't wait until we're back on social media. Reach us now through employmentlawyer.ca. Let us roll up our sleeves and get to work and help you. All right? Thank you so much. I'm Lior Samfiru, the employment lawyer. Thank you for joining me. I'll be back soon. Until then, wishing you all the best. Take care.